in the police, which is an executive arm of the government. Now, I ask the question, can the courts display the same degree of activism in the enforcement of socio-economic rights encapsulated in Chapter 6 of the Constitution, that is, the directive principles of state policy? Ask yourself the question, can that same activism be transposed and be displayed with regard to the directive principles of state policy, which is in Chapter 6 of the Constitution? Now, day in and day out, fundamental rights applications are instituted for the violation of these principles. Now, take Article 27, Sub-Article 2, which states that the state is pledged, pratignyavakti, to ensure the realization of adequate standards of living, which includes food, clothing, and housing, for example. Now, in the same breath, this chapter in Article 29, having said it in 27, in 29 says that the directive principles of state policy do not confer rights or duties and they are not justiciable. අධිකරණයකට ගිහිල්ලා නඩු නිමිත්තක් අපිට ගොඩ කරන්න බෑ, ඉදිරිපත් කරන්න බෑ ඒ පදනම මත. එහෙම අධිකරණයට ගේන්නත් බෑ කියලා මේ අපේ ව්‍යවස්ථාවේ සක්සුදක්සේම පැහැදිලිවම පෙන්නලා තියෙනවා. Now, one reason why the Constitution shuts out these areas from the scrutiny of the Supreme Court, why do you think why are they doing that from the Supreme Court, is, in my view, is that resource allocation is a matter for the legislature and executive. Resource allocation. It can't be anything else that I can think of. Resource allocation. Should the court, therefore, intervene in these areas? The question I put to you. Say that the court fixes tariff and imposes it on the executive. The courts tomorrow, I decide with the other judges, we decide what the taxation rate is going to be, what the fuel price is going to be, how much you will pay for your telephone, for your mobile phones. Can I do that? Fixing of tariff? However good intentioned, right? However good intentioned and laudable this may be, there must be the parameters of this exercise. යම් කිසි පරාසයන් ඔස්සේ ඒ බලය පාවිච්චි කරන්න පුළුවන් කියන එකයි මගේ අදහස. Unless the court makes a connection, how do we do this? Is it possible? Unless I say the court makes a connection between the directive principles of the chapter on directive principles and the chapter on fundamental rights. I think that is the only way, if at all, one can reach the socio-economic rights which are actually enshrined in the directive principles of state policy. The courts will have to come up with a mechanism that establishes a link, a connect between the directive principles and the fundamental rights chapter. So therefore the court cannot render the directive principles on the face of it enforceable. Now no one can come to court and say, I don't have a house, give me a house. No way. You won't get it. That's not available as presently constituted. Now this is what the constitutional order, presently the Grundnorm of the country actually imposes. The Grundnorm of the country imposes, that is how it is presently. Maybe in time to come we might change the constitution. We might find the connect. We might put down the rationale for it. But as it stands today, the Grundnorm doesn't permit that nexus between the directive principles, although the courts have time and again endeavored to do it, but I don't think they have successfully done it with the right reasons been adduced to doing so. So therefore, ladies and gentlemen, it follows that in every country in which courts have some role in determining whether the executive complies with the Constitution, the primary judicial role in contributing towards good governance is to perform this task assiduously and without fear and favor or prejudice. That's the way to try and satisfy the courts, the functions of the courts. How they contribute to good governance is to perform this task assiduously without fear, favor or prejudice. Now, these are very easy things to say. Fear, favor, prejudice. After all, we are all human. We are not superhuman. We are all subject to human frailty. subject to the qualification that we will do our best to try and achieve these standards. And these standards, as you know, are not rigid standards. These are standards that keep on changing from century to century, time to time. Societal needs being different. You will remember that what was the sport of kings, even today in the United Kingdom, horse racing, is illegal in this country. Now that is what it is. When maybe in time to come we might say, well, there's nothing wrong with that. And there are lots of other laws like that, which keep on changing, and maybe as far as we are concerned at the moment, that is where we stand. So therefore it is of course true that the powers that determine whether the other branches of government comply with the Constitution is not always conferred on the courts. In other words, it's not the court that you must always come to complain about the other branches of government. There are the other, for example, we have the Public Service Commission. We have the Administrative Appeals Tribunal. We have the Labour Tribunals. We have the Insurance Board. We have the Tax Appeals Tribunal. And we have a host of other. We have the mediation boards. And let me tell you that in time to come, in the future, the mediation procedure will take pride of place in the dispute resolution mechanism, and I can assure you that that has been identified as perhaps the way out of most of our problems in the whole region, and perhaps even universally. So countries like France, for example, have other independent mechanisms to achieve the same results that we achieve in our courts. Now, the judiciary has a lesser role in ensuring good governance in countries where they do not have the power to determine whether the government has complied with the Constitution. Now, ladies and gentlemen, after all, you will agree that after all, that the attainment of a just society is the object of most constitutional democracies. To that end, I say that the judiciary is enjoined to promote the rule of law by exercising its powers given to it by the Constitution and any other statute. Now, let me wind up in this way. The exercise of public power must, I say, comply with the Constitution, which is the supreme law, and the doctrine of legality, which is part of that law, the doctrine of legality. Now, the doctrine of legality, which is an incident of the rule of law, is one of the constitutional controls through which the exercise of public power is regulated by the Constitution. It entails, what does it mean? What follows from that? It entails that the executive, I quote, is constrained by the principle that it may exercise no power and perform no function beyond the powers that are conferred on them by law. Close quotes. That is the doctrine of legality. If you read Wade or Dicey or whatever it was, you see the doctrine of legality very commonly laid down. Now, in this sense, in other words, no person shall, in the executive, act beyond its powers, in other words, beyond act ultra vires. Now, in this sense, the Constitution entrenches the principle of legality and provides the foundation for the control of public power. That is my submission. The Constitution entrenches the principle of legality and provides the foundation for the control of public power. Now, even if all others were to enable, if all others were unable, even if all other organs of state were unable to give practical expression to the rule of law, let's assume that everyone, all the organs of government are not going to be interested in the rule of law. After all, the man who holds an inquiry under the Paddylands Act, sitting in Agurumala Palace, is not going to know about the rule of law. But he certainly will know what he can do and what he cannot do. That is what it is. So if all others are unable to give practical expression to the rule of law, human rights, I say, human rights and constitutional aspirations of the people in any democracy, particularly in a constitutional democracy, I say human rights and constitutional aspirations of the people would survive even if you had, perhaps, you are not fully appreciative of what the rule of law is. Now, what is the upshot of this? I say that that can only survive, that right can only survive, human rights and the constitutional aspirations of the people. Now, these are very dangerous word to use, the aspirations of the people. Not to carry Molotov cocktails to a, no, those are not aspirations, to a peaceful, so-called the peaceful demonstrators come to demonstrations with Molotov cocktails, knives, swords, hand bombs, hand grenades. Now, these are supposed to be, these are some aspirations of some people. These are not the constitutional aspirations. They can't be constitutional aspirations. Now, I'm not talking of that kind of aspiration. I'm talking of constitutional aspirations that actually survive and are really the high values of life. And I say that that can happen, that can only survive, provided a truly independent body of judges and magistrates, loyal to the oath of office, or a solemn affirmation, is in place and ready to administer justice to the aggrieved in terms of their oath of affirmation, not to end up buying a property from those of whom you try. I'm not talking of that kind of oath of office. Who are loyal and deeply loyal to the oath of office that they have taken, that they will serve the rule of law. And that is the oath of affirmation, I say, to the faithful, to be faithful to the Republic of Sri Lanka. To be faithful to the Republic of Sri Lanka. Now, who is the judge, I ask? I say this so that I can be quoted 1,000,000 times. Who is the judge who can actually live up to that affirmation if he is not faithful to the Republic of Sri Lanka? To uphold and protect the Constitution and the human rights entrenched in it, and to administer justice to all persons alike without fear, favor, or prejudice, in accordance with the Constitution and the rule and the law. I don't think there is any compromise on that. And I need not say anything more than that. Central, therefore, with all respect to the affirmation or oath of office, Dean, is the obligation, I say, to uphold the foundational values of our constitutional democracy. The foundational values. Ape prathamika gunayan. The foundational values to uphold of our constitutional democracy, which includes the rule of law, human dignity, equality, freedom, transparency, and accountability. That is the golden paradigm, I say, towards which we will march together. Do not get me wrong. I do not want to be misunderstood. Do not get me wrong. The judiciary cannot achieve this objective only by itself. We cannot achieve it on our own. Just as much as the bar is an important adjunct to the bench, the civil society should play a cogwheel role in the deliberative and participatory governance process. You all know that we brought out a national action plan on human rights for the protection and promotion of human rights because the representative of civil society had a lot of input that was put into it. We were successfully able to do that because civil society actively participated in that process. We need to develop as an investor-friendly nation, don't we? Recently, I have actually told our judges that the community will be willing to actually invest in the judiciary, provided, like all other investment, there is a good return for that investment. Now, is that a wrong thing? Like any other good return? Can we sit back and wait and say we are not going to play an active role in the development process? Can we say that? Can we have a judiciary that takes 5 years to recover 100,000 rupees? Can we have a judiciary that will take 10 years to settle a land dispute? Surely not. Then how attractive can we make, how attractive a nation can we be to, for example, from the point of view of our investor? When those investors do a due diligence of this country, they will want some lawyer who does their due diligence to say, well, Sri Lanka has a dynamic, vibrant, efficient legal system. Not an archaic museum piece. Not judges who come at 8 o'clock in the morning and get into their cars at 4 o'clock in the afternoon and just go off without being sensitive to what is going on. Can we be so divorced from that system, I ask? I say no. The answer to that is no. And I can tell you, as sitting in this seat of mine today, I intend to do something serious about that. And we intend to put in judicial reforms that will end the woes of the litigants that have been traditionally seen to burden them for the last few centuries, perhaps. I'm not, for example, I'm optimistic that we can do it. Now, so therefore, we need to invest, as I develop an investor-friendly nation, we need investor-friendly laws such as a modern arbitration center. Modern arbitration techniques, our Arbitration Act is archaic. We are intending to support or set in place a modern mediation center, court-assisted mediation and outside court mediation. In India, recently I had a long meeting with the Chief Justice of India at which he explained to us what they have what is known as a mediation. There is a court, there's a special act that offers mediation at provincial level, that offers mediation at district level, that offers mediation at village level as an alternative to the traditional ways of litigating. And he told me, His Lordship as Chief Justice of India told me, that 50% of the backlog of their cases they have actually managed to address. So therefore, ladies and gentlemen, we need, as I said, like in Singapore, they have their modern arbitration. Why does everybody go run there? Not because they have the love of Singapore, because they probably have a very modern arbitration center that finishes dispute resolution in a matter of days. And that is precisely what we are trying to shape up to in the times to come. Now, that will promote the rule of law, I say, and therefore, thus, in the end, sustainable economic development. The judiciary, I say, will play its role in the role of rendering assistance to such a process. We are in the process of capacity building for our judges. As we speak today, I have 30 judges who have just come back from a training session in Bhopal. We had 100 judges trained in the last 2 weekends in a local resort. We have 50 other judges going to Hong Kong in the month of November and another 50 in the month of October. So that is the kind of investment that we are doing in the judiciary, and they're all excited about doing things differently. And we hope, we have been very optimistic, I hope that optimism will pay off, but we are of the view that given that capacity, that we can deal with the legal system, make this legal system a much more efficient place where Sri Lanka will be a very healthy place for even investors. Therefore, your theme today, that Sri Lanka as a hub in Asia, the way forward is both timely, Dean, and appropriate. Towards that end, the judiciary is an equal partner with you within its permissible bounds. The future, I say, ladies and gentlemen, is full of promise, as it is fraught with, inasmuch as it is so fraught with uncertainty. The industrial society, you will see, is giving way to one based on knowledge. Today, the society is giving way to one based on knowledge. The new divide, I say, in the world is between those with the knowledge and those without knowledge. That is the clear difference. Either we become a nation of knowledge, a very knowledgeable nation, or a nation who pays scant regard. And I think we are far from the latter category. We are a nation so resourceful, plenty of human resources, and we are definitely a nation that can be identified with that category of being a nation full of knowledge. So what is the ultimate? That we have, you will see that we have succeeded in education, but that success in education does not ensure results in the future. However, we stand, I say, a better chance of not falling if we abide by the basic principle that will help us in our progress of equal opportunities for all and meritocracy. This will take us, I say, with all respect, to the ultimate goal of making Sri Lanka a model and a hub. I assure you that the judiciary will be a constant companion in that journey by ensuring that the rule of law will prevail. Now, ladies and gentlemen, before I part, may I say this? I can easily pay lip service to all what I said, walk away here to meet you again perhaps next year. We are not intending to do that. I can assure you the judiciary is presently in a mood to deliver. And that those deliverables can only come if we all, as I said, the judiciary alone cannot be part of this process. The bar has to play a very vital role in that process. Can we, for example, I can tell you, a few weeks ago we had, that's not a new phenomenon, my friends here at the bar will tell you, we have cases which are 30, 40 years old. And the argument simply is, send it back to where it came from because there's something wrong in the reasoning. We have said no. How wrong? Whatever the wrong in the reasoning may be, we will hear it now. There is no question of sending it back for another 40-year run until you and I are dead and gone. The judiciary is not in a mood to entertain that kind of thinking. So let us, and I say, with you at the helm of things, if all of us join hands together in this one process, and that is we will lift our country from those difficult days that we experienced for 30 years and restore that glory that we once enjoyed, your forefathers enjoyed. I'm sure I have every confidence with you and with the kind of capacity building and the resources that you are exposed to today, that our job in the judiciary will be an easy one. I wish you every success in your studies, and may I thank you for the invitation that you extended to me to address you this afternoon. Thank you.